Hi, everybody. Back here with our second narrated PowerPoint session. So this time I'm going to be covering the agenda for September 12th. And so, as a quick reminder, in our first class session, we talked about the promises of the law, specifically the first promise of the law, which is orderly dispute resolution. And then in the video that I uploaded the other day, the material on September 5th, we talked about the second promise of the law, which described the court's role as a policy-making body. So what does it look like when the courts make policy? How does that compare to other policy-making outfits like the legislature, for example? And then kind of attached to that role is the court's ability and promise to step in and correct political failures. And we've seen that the court has been able to do that in some cases. For example, Brown versus Board of Education, the 1954 U.S. Supreme Court case that desegregated schools in the United States, is seen as sort of um, a landmark case where the court was really able to step in and do something that the elected branches were not able to do. So what we're going to do here today is talk about the limits of law in courts. And so we've talked about the two promises and what the courts can accomplish in terms of orderly dispute resolution and correcting political failures. And today we'll move to the limits of law in courts. There are three of them, and I'll spend a lot of time on each one, but the first are what we consider doctrinal constraints, and these are constraints on the courts as a policymaker that stem from the law itself, so what the law says the courts can or cannot do. The second type of constraints are institutional constraints, and there are a couple different versions of institutional constraints. The first is how the courts are organized internally, and the second are how courts are organized externally within the American political system. So, how do they interact with the other branches of government and the bureaucracy? And then third are cultural or economic constraints, and we'll mostly refer to them here as cultural constraints. And this one it basically talks about how the court, though it's unelected, is unwilling to move too far outside the mainstream of American opinion, even though if they did, um, there wouldn't be any electoral consequences, right? Because U.S. Supreme Court justices are appointed for life. All right. And then we will put it all together based on the landmark book of Gerald Rosenberg that was published in 1991, where he combines these sorts of views into a debate that he calls the constrained court view versus the dynamic court view. All right. So before we get into the limits of law in courts, I'd like to take just a second to go back over the sources of legitimacy for each of the two promises of law in courts. And so the first source or the first promise of law in courts, which is orderly dispute resolution, the source of the legitimacy is the logic of the triad, which we have talked about, which we talked about in class pretty extensively. So an example of this, we had two sort of examples that we talked a little bit about, but the first is U.S. versus Nixon, which is the Supreme Court case from the 1970s where the Supreme Court demanded that Richard Nixon turn over tapes of conversations that had been recorded in the White House that were potentially pertinent to the Watergate break-in investigation. Nixon claimed that he did not have to turn over the tapes because doing so would violate executive privilege, which is a constitutional right of the office of the president. And the Supreme Court ruled that no, in fact, it would not violate executive privilege, and he was forced to turn over the tapes. And so, in this case, the court is truly acting as a referee. They're interpreting the law, and despite going up against the office of the presidency, which is one of the most, or is the most powerful political office really in the world, the court was able to compel Nixon to turn over the tapes. And similarly, in Bush versus Gore, the 2000 Supreme Court case where the court halted a recount in Florida, they upheld the logic of the triad, not in their actions so much, but in Gore's actions, because Gore of course, did not challenge the ruling and conceded the presidency to George W. Bush, even though he had a pretty good legal case as to why the recount should continue. So when it comes to orderly dispute resolution, the source of legitimacy here is the logic of the triad, the 2-against-1 relationship that we talked about in class on August 29th. So the second promise of the law, correcting political failures, involves a different source of legitimacy. And here, the source of legitimacy is the perceived prudence by elites and the public. And so it can't rule, the legitimacy can't be based on the logic of the triad, because here the court is not serving as simply a referee that's calling balls and strikes or an umpire, but instead the court is injecting itself into the policy-making process, right? So in the case of Brown versus Board of Education, which is our example here, the court acted because the elected branches of government, the presidency and Congress, for reasons we've talked about, were unable to act or were unwilling to act. And so the court literally stepped in as a policymaker. And so they can't just argue that they're serving as a neutral referee, but instead they have to appeal to the rule of law, or the quote unquote, it was the right thing to do. And this is, of course, very risky for the court to do things this way, because what is right for a lot of people may not be right for some other people. And in the case of desegregation of schools, I think we can all agree that they made the correct decision. But you can see that this might not always be the case, right? All right, so let's do a brief overview of the 3 constraints that I mentioned in slide 1. So you have doctrinal constraints, institutional constraints, and cultural constraints. Doctrinal constraints, as I mentioned, are formal limits on the courts. And these constraints are derived directly from statutes. They're derived from other court decisions that have served as precedent, or they're derived from administrative regulations, which are often binding. And so here, and we'll go through some examples of these in a second, but these are written down rules that judges, despite their inclination to step in potentially in a policy-making environment, keeps them from doing so, all right? The second form of institutional constraints, or second form of constraints rather, are institutional constraints. And I talked a little bit about these on the first slide as well, but there are 2 types, which internal is the first, and this is the way in which courts are organized. So in America, and we'll talk more about this in part 2 of the course, but in America we have a very Byzantine and confusing and overlapping system of jurisprudence. So we have federal courts, we have state courts, and oftentimes, because of these sort of decentralized centers of power within the American judicial system, it's very difficult for courts to act in a unified and cohesive way. The second form of institutional constraint is an external institutional constraint. And this is ways in which the court can or cannot act or interact with other external actors, like the president or Congress. Congress, for example, can potentially override judicial review. And so this is can be problematic for the court. We'll talk more about that. Cultural constraints are limits on the courts that stem from elite or public opinion. And again, the court exists within culture in the United States, not outside of it. It's important to remember up front that these are general descriptive categories. They're not watertight compartments, and that some constraints can actually fall into more than one category. Okay, so on to doctrinal constraints. And here are 3 examples of doctrinal constraints that do a good job of illustrating the fact that that doctrinal constraints can have different degrees of kind of ability to keep the courts from doing things. And so there can be a low-level doctrinal constraint, there can be a mid-level, and then a high level. So we'll go through them one by one. So Article 1, Section 8 of the Constitution includes the necessary and proper clause. And so this, as you may imagine, is a minimal constraint on the court. And why is it a minimal constraint on the court? Well, it's minimal because what does necessary and proper mean? It means whatever the court says that it means, right? And so what is necessary and proper? Well, that falls to judges to tell us what necessary and proper is. So there's a lot of latitude there, right? You can imagine when you were growing up, if your parents say, I have one rule, and that rule is be a good person. Well, that gives you then a lot of latitude in your everyday behavior. As long as you're generally following the edict of being a good person, you can behave in all sorts of different ways, right? And so here we can see that the courts can do the same. So an example of a mid-level institutional constraint, or doctrinal constraint rather, is the Fourth Amendment in the Bill of Rights, the U.S. Constitution. So this is, of course, the unreasonable searches and seizures amendment, and it is a little bit more specific than necessary and proper, right? But at the same time, what is unreasonable? What counts as a search? What counts as seizure of property? Again, these are questions that it's up to judges, it's up to courts to decide what they mean, right? And so while the court is constrained a bit more than they may be with the necessary and proper clause, still there's some latitude for them to operate. An example of a significant level of doctrinal constraint is the Seventh Amendment. And here, the amendment is written in such a way that the court really doesn't have very much latitude at all in determining its meaning. So this is where Americans, by virtue of citizenship, are offered a right to a jury trial in controversies that exceed $20 in damages. So, as written, the language is not that exceed $18 or $19, but it's a very specific dollar amount that prescribes what the court can and cannot do. So how do we know that the law matters as a constraint, right? And that doctrine matters as a constraint? Well, a couple different ways. So one, we can look at what we call textual analysis, and here's where you'd be reading a majority opinion, for example, where a court in the majority opinion may say, look, we wish we could have ruled on this, but the law keeps us from doing so. We just can't do it. Or secondly, we could think of the concept of judicial cant, and this is where a court may not even be able to take a case at all. So here you're analyzing the behavior of a judge or a court. So this is a form of behavioral analysis. So sticking with doctrinal constraints, there are a couple different kinds, right? So we've seen that there are low-level, mid-level, and significant doctrinal constraints. But exactly what is doctrine constraining, right? And so the first of these two types are constraints on judicial power. And these concern the limits on the court's ability to act at all right? And they're often talked about or referred to as the rules of justiciability. And so this is kind of an awkward word, but what does it mean? Well, it means basically prescribing when the court can and cannot take a case. So there are all sorts of terms that if all of y'all go on to law school, you will talk about it at great length in your civil procedure classes. But for example, mootness, ripeness are just two of them. And so if the court is unable to see that any damage, any actual damage rather than just hypothetical damage has been done to the aggrieved party, then the court has no standing to take the case, right? So this is an example of a rule of justiciability, and sometimes it can actually constrain the court's ability to act at all. There are also constraints on judicial coercion. And if you're familiar with the word coerce, it means to convince somebody to do what you want them to do. And so these refer to limits on the court's ability to implement decisions. And put simply, what this means is that the court can't go out into the community, right? They're limited. They can't do this. They can't go out into the community and ensure that all of their edicts and their decisions are being followed to a T. So, for example, in Brown versus Board, the 9 Supreme Court justices did not go to every school district in the South and make sure that the school districts were being desegregated with all deliberate speed. All right? So there's an example in the reading of what happened with Hurricane Katrina, and we'll compare and contrast this to Brown versus Board in just a second. But the reading, I think, is really illustrative of this concept of a doctrinal constraint, and so we'll go through the example. So Hurricane Katrina, of course, was the very damaging hurricane that destroyed much of New Orleans in 2005 and decimated parts of the Mississippi and Louisiana Gulf Coast. So politically, the aftermath of Hurricane Katrina created a large class of claimants, and they were seeking compensation for their losses. So if you think back to last week, we talked about the ways in which courts can make policy and how that kind of compares and contrasts to other policy making apparatuses within American government. So, if you remember, we talked about claimants being mobilized. So, in this case, the hurricane mobilized a large class of claimants who wanted to be compensated for their losses. So, just like in Brown versus Board, they first turned to the elected branches of government. So, they turned to Congress, they turned to President George W. Bush, they turned to state legislatures. Unlike the desegregation example, Congress and the president were very willing to act. And in fact, in the immediate aftermath of Hurricane Katrina, they passed a spate of legislation to the tune of $62 billion that were approved for reconstruction of the Gulf Coast, among other remedies. So unlike Brown, it's not that the legislative option was blocked, right? And in Brown versus Board, we talked about how there were Southern Democrats who were pro-segregation, who would keep any pieces of civil rights legislation from ever leaving committee. So unlike Brown, it's not that the legislation never happened. It's that the legislation proved to be ineffective. And this is a really different type of political failure, right? So it's not that the branches won't act at all, it's that when they do act, it doesn't work. And so the promise is, well, when the elected branch's response fails, what do you think will happen? You'll go to the courts, right? And so the plaintiffs filed a class action lawsuit against the Army Corps of Engineers, which is essentially an administrative agency at the federal level. And this lawsuit was based on design flaws of the levee system that they had designed and constructed to protect New Orleans. So here are where the limits come into play, and this is an example of judicial cant. So under the Flood Control Act, which is a piece of federal legislation passed by Congress, the Army Corps of Engineers, by law, cannot be sued by private parties. And in 2008, 3 years after Hurricane Katrina made landfall and with such damaging effect, Judge Duvall, who is a federal judge in the Fifth Circuit Court of Appeals, upheld this limitation on judicial power. And this is despite the fact that he vociferously disagreed with the requirements of the Flood Control Act. And in fact, in his opinion, he claimed that the agency, the Army Corps of Engineers, was guilty of gross incompetence. So what this means is that the judge wanted to act in favor of the plaintiffs, right? He wanted them to be able to recover and recoup some money for the loss of livelihood and loss of homes and loss of other types of property. But he couldn't, because doctrine, in this case law, in this case the Flood Control Act, tied his hands and said, no, the Army Corps of Engineers, despite being partially responsible for this disaster, cannot be sued. So in this case, this is evidence of a doctrinal constraint. All right, so to go back to the comparison that we hinted at briefly a few slides ago, now let's sort of systematically compare the cases of Brown versus Board and Katrina. So in each case where there's sympathetic plaintiffs, and I should mention here that plaintiffs, that's the party who brings the lawsuit, right? So in Brown versus Board, you have essentially black school children who are represented by the NAACP, who are suing so that they can go to school and better facilities with white children. So are they a sympathetic class of plaintiffs? Yes. Are people who have lost their homes, their businesses, in many cases, the lives of loved ones, are they a sympathetic class of plaintiffs? Yes, they are, right? So an example of a non-sympathetic plaintiff may be a neo-Nazi group who is represented by the ACLU and claiming that they have a right to free speech. So the neo-Nazis are not sympathetic plaintiffs, right? But in this case, the people who were harmed by Katrina and the people, the school children who wanted their schools to be desegregated, they're clearly sympathetic. Were the facts good in both cases? Yeah, they were. So in Brown versus Board, it was not difficult at all for judges to take a look at the vast majority of so-called colored-only schools in the South and say these are clearly inferior to the schools that white kids are going to. And in Katrina, the failure of the levees was catastrophic, right? And the levees clearly did not work as they were designed to work. Was there a promising legislative path for remedy in both cases? Well, in Brown versus Board, as we've talked about, no, there was not a promising legislative path because Southern Democrats refused to ever allow legislation to come to the floor. Katrina, there was also not a promising legislative path, but for a different reason, right? Congress had already tried to compensate these losses and had failed. Were there sympathetic judges in both cases? Yes, there were. So the Supreme Court ruled 9-0 in Brown versus Board of Education. And as we just saw, Judge Duvall in federal court was clearly sympathetic to the Katrina plaintiffs' cause. So these cases are similar on all of these respects except for judicial policymaking. So was the court able to make policy in Brown versus Board? Yes, they were. They were the ones who issued the order to desegregate the schools. Was the court able to make policy, in the Katrina case? No, they were not. And the reason why they were not, as we've just talked about, is because they were limited and constrained by doctrine. All right, so moving on to the second type of constraint, which we call institutional constraints. And as mentioned, these are limits on the court and the court's behavior that stem from the ways in which courts are internally organized and the ways in which courts interact externally with other political actors like the president, Congress, bureaucracy, etc. And so I'll give you some examples of both of these different types of institutional constraints. And the reason why they're called institutional constraints is so in political science we call Congress, the presidency, and the executive branch, the legislative branch, and the judicial branches, we call them institutions, right? So these are institutions that we study. And so in this case, we call this constraint the institutional constraint because it talks about how the courts are actually organized and how they interact with other actors. Okay, so speaking of interacting with other actors, we see that the court is constrained by the presidency and the Senate in that courts cannot go out and recruit their own judges, okay? And what I mean by that is any organization, imagine a business that you go work for, if you need a better employee or you need another employee because the workload is too high, in most cases, if you have the money to afford to be able to do so, you'll just go hire somebody, right? And the federal courts can't do that. So the federal courts are reliant on the president to nominate somebody to fill a vacancy, and then they're reliant on the Senate to confirm that person. And so the key concept here is that ideology is a predictor of future decisions. And so as a result, the president and the Senate are very careful about who is nominated and appointed, or who's nominated and confirmed, rather, to serve on courts. So the other external constraint, example of an external constraint, is an override. And this is where Congress with a supermajority can override a judicial decision. And so the key concept here is that Congress can send a court repeated signals that they feel as though they disagree with a ruling and can eventually override it. Okay, so moving on to examples of internal institutional constraints. And remember, these are constraints that deal with how the courts are organized and also deal with how the courts can operate on their own. So courts are passive. The previously mentioned rules of justiciability apply here, and these can be both doctrinal and institutional. And there's also the role of legal resources in setting the judicial agenda. And here we refer to the Galanter reading, which I'll talk more on in just a second, right? But the key concept is that courts have to rely on motivated plaintiffs to bring them cases. And in some cases, plaintiffs who have a very good case, right, and who the court would be naturally sympathetic to, they may not have the money to bring a case all the way to the Supreme Court. They may not have the resources, the legal resources or financial resources to do so. And then secondly, courts are internally fragmented. So sociologist Max Weber, German sociologist, talks a lot about how bureaucracies work and organizations work. And he says the most effective way for a bureaucracy or an organization to function is through a sort of top-down chain of command, all right? And we see this in corporate America, we see it in the military, we see this all over the place. This is This is a recipe for fast, efficient, responsive action in the face of a pressing need. Unfortunately, for the courts in the policymaking game, the courts are organized the exact opposite of this, right? So there is the U.S. Supreme Court that stands at the top of the food chain, but there are also 14 Circuit Courts of Appeal. There are 51 versions of different state court systems throughout the United States. And so as a result, when courts try and step in to make policy, they often find themselves probably quite frustrated by the fact that there may be simultaneous rulings coming down from different courts throughout America, and it can be pretty difficult. All right. So more on this, courts are passive institutional constraint. So Mark Galanter, in his book Why the Haves Come Out Ahead, he mentions two classes of litigants. And so when I say litigants refers to people who are involved in civil litigation before a judge or a judge and a jury. And so the first classification of litigant that he talks about are what he calls repeat players. And these are litigants who are engaged in many, many similar cases over time. So, for example, let's take an insurance company. So, an insurance company, the lawyers that represent an insurance company and the lawyers that work inside the insurance company spend their entire careers defending the insurance company against very, very similar cases. So, normally it's plaintiffs who claim that the insurance company did not pay on time, or plaintiffs who claim that the insurance company is withholding payment for a loss erroneously, right, and that they actually do deserve payment. But nevertheless, these are lawyers who are experienced. They are lawyers who are in the court system a lot, and they have a lot of resources, and that's why Galanter calls them repeat players. On the other side of the spectrum are what he calls one-shotters, and I've abbreviated these throughout the slides as RP and OS. One-shotters are litigants who have only occasional, this should say recourse, not resource, but only occasional recourse to the courts. So you can imagine one of those insurance cases where you have, house insurance and a hailstorm hits your house, and you sue your insurance company because they're refusing to pay for a new roof, despite the fact that you think that it should be covered under your policy. And so in that court case, you've hired a lawyer, no guarantee that he specializes in insurance cases. He may not even be a very good lawyer because you might not have that much money. Whereas on the other hand, you have the insurance company, I don't know, let's say it's State Farm or Farmers, one of the giant insurance companies that's all across America. And those insurance companies, as I mentioned, are in court constantly doing the exact same type of cases, right? So who do you think is going to be advantaged here? Well, it's going to be the repeat players who tend to come out ahead. And they tend to come out ahead because of greater resources, both money, time, legal expertise, etc. They also have greater access to specialists. These are sometimes expert witnesses who are often on retainer at a law firm, and they'll testify over and over and over again in court. They also strategically use conflict of interest laws to keep certain law firms out of the game. They also, and this isn't even always done with bad intentions in mind, but if you're a lawyer and you appear in court over and over and over again, you're going to start to develop some kind of relationship probably with the judge and other legal decision makers. And finally, they play the odds, and they play for the creation of the rules over time. So the key point here is that high costs of the American legal system and the uneven distribution of legal resources, what Galanter talks about, these can serve as a significant limit on judicial power, because if certain groups lack access to lawyers or sufficient resources to litigation, they cannot, or at least are very, very unlikely, to be able to file a lawsuit and bring courts into the policymaking game. High costs create a barrier to entry, with lawyers serving as the primary gatekeepers to the system. Right? So again, the takeaway here is that even if courts are sympathetic, the fact that courts are passive and the fact that going to court is expensive and hiring a lawyer is expensive, it often means that people and companies and organizations who are involved in similar types of litigation a lot and over time, they have structural advantages compared to people who are one-shotters. All right, so just to do a quick sort of comparison of institutional constraints concerning how the courts themselves are organized. We talked a few slides ago about Max Weber and this sort of ideal bureaucracy that's organized hierarchically and top down, et cetera, compared to the US courts. And so in a Weberian bureaucracy, what does the chain of command look like? Well, it's clear and hierarchical. What does the chain of command look like in US courts? It's very muddled and it's balkanized, which means separated. What are the rules and procedures in a Weberian type ideal bureaucracy? They are clear. What are the rules and procedures in US courts? They are unclear. And what I mean by unclear here is they're often overlapping, right? So state courts, municipal courts, courts of appeals, federal courts, the Supreme Court, etc. And the level of specialization in an ideal type bureaucracy is very high. So you have people who are trained to do one thing. The average judge in the US is not trained to do one thing, but has to hear an incredibly wide array of cases that may have to do with all sorts of different substantive issues. There are some courts of specialization in the US. There are family law courts, for example. There are juvenile courts. There are probate courts, which are courts that hear cases dealing with bankruptcy. But by and large, judges in America have to be jacks of all trades. So what? So all things being equal, internally fragmented courts will not act in a coordinated fashion. And this can be a significant limitation on judicial power, for example, because one court can't speak for another, and judicial coercion because the courts won't speak in a single voice. And so if you're getting conflicting rulings and you're trying to, adhere to multiple different sort of versions of the law, it can be a very confusing situation, a very confusing policy-making environment. All right, so moving on to our third type of constraint, we have cultural constraints. So we'll focus a little bit less on this today than the other two, but they're still important for our story. So cultural constraints are limits on the court that can stem from elite or public opinion. So examples here include the readings on Mexico's war on drugs, the child falling out of the window in the Bronx, there just being a lack of sort of cultural justification to get these kind of laws remedied and to get these apartment buildings that poor people inhabit brought up to standard. All right, so summing up constraints. The source of doctrinal constraints is the law itself. The source of institutional constraints are both internal, so how the courts are organized, and external, how the courts interact with other branches. And the source of cultural constraints concerns elite and public opinion. As for constraints on judicial power, when it comes to doctrinal constraints, there are those rules of justiciability. So sometimes a court can't take a case even if it wants to. An example on coercion when it comes to doctrine includes damage caps on remedy law. So for example, in the state of Texas, if you are the victim of a medical malpractice case, the legislature has determined that you can only receive several $100,000 in damages despite the fact that your injuries may be catastrophic. As for institutional constraints, the constraints on power in the institutional level are fragmentation and passivity, and the constraints on coercion at the institutional level are the inefficiency of the courts and checks and balances. Constraints on power when it comes to the cultural constraint are reluctance of courts to even get involved in an issue, and constraints on coercion refer to the resistance of target subcultures, which the reading talks about. All right, so let's sum up this debate, right? So we've spent the past really 3 class sessions, if you include these 2 videos, talking about when the court can deliver on its promises of orderly dispute resolution and policy making and when they are limited, right? And so what Rosenberg does is he combines these views into something called the constrained court and dynamic court debate. And so this is, we're going to call it the CCV versus DCV debate as we move throughout the semester. But it's going to be something that really animates much of the rest of our discussions in class. So it's really important that you have a good handle on it. Also on page 241 in the book, Barnes goes over what this debate kind of means. All right. So like I said, it stems from Rosenberg's landmark 1991 book on the power of the American court system. And he essentially asked the question, are the law and courts a powerful and effective player in the policy-making game, or are law and courts limited in what they can accomplish when it comes to policy-making? And doing a dichotomous characterization like this, because of course the real answer is like, well, sometimes they're limited and sometimes they're not, right? But dichotomizing something like this allows us as social scientists to set up what we call competing explanations, to identify their observable implications and assumptions, which will allow us to potentially test and generate theory. And so this is a central process to the generation of social science research. And generating and probing hypotheses is really what distinguishes us as social scientists from historians and journalists. Okay, so here is a table, also found in the book in slightly different form, summing up these views, all right? Okay, so the core metaphor of the constrained court view, before I get to that, I'll go through what these categories are. So you've got the core metaphor, you have doctrinal constraints, you have internal institutional constraints, external institutional constraints, cultural constraints, and what kind of conception of politics are we talking about? I'll talk a little bit more about this when I get to this particular part of the table. So the core metaphor in the constrained court view, right, which refers to the constraints that we just talked about being, pretty effective. So the core metaphor here is what economists might call the principal-agent relationship. And here, the court would be considered the agent of the principals, which are the elected branches. And so because of passivity and fragmentation and all of these things, the courts are often left to do the bidding of the elected branches. The courts cannot jump unless the branches tell them to jump, all right? Doctrinal constraints in the constrained court view are strong. Given that the law is socially constructed, it represents usually the will of popularly elected lawmakers, etc. Internal institutional constraints dealing with passivity and fragmentation are also strong. So courts are dependent on lawyers to bring them information. Claimants often have very uneven resources. As far as fragmentation goes, there are conservative circuit courts, the Fifth Circuit Court of Appeals, which Texas is located in. It's headquartered in New Orleans. It's seen as a very conservative circuit court. On the other hand, the Ninth Circuit Court, which encompasses most of the western U.S. and is headquartered in San Francisco, is seen as a very liberal circuit court. So this makes policymaking hard. There can be competing rulings, etc. Externally, the appointment process can serve as a check on the court's behavior. And not only that, but specific rulings can be overridden by Congress. Culturally, the constraints on the court can be very strong, given the fact that the courts have to persuade the other branches of government or the bureaucracy to actually implement their decisions, right? So the court can't go too far outside the mainstream of public opinion. The implicit conception of politics that we're talking about here is a conception of politics where preferences are fixed, okay? And I'm going to come back to this in a second. But that if what we mean when we say politics and what we're talking about when we talk about politics is the distribution of goods and services, all right? So for example, in Brown versus Board, the court ruled in 1954 that schools should be desegregated, right? And this was held as a landmark sort of event in judicial power in American history. But even as late as 1990, federal courts were still saying that Dallas County schools, for example, were not desegregated. And so if you think of politics as a distribution of goods and services, right? So the court distributes desegregation. Do they do a good job of doing that? And the argument in the constrained court view is no. If 36 years later we still have segregated schools in the South, then no, the court isn't good at doing this. All right, so let's turn our attention to the dynamic court view. So the core metaphor here is not the principal-agent relationship, but is instead that the court serves as one independent center of power in American politics. And so there's a constant tug of war going on between the branches of government that do overlap one another, but that all check and balance each other. Doctrinal constraints are weak, right? We saw, for example, the necessary and proper clause in Article 1, Section 8 of the Constitution. Well, what does necessary and proper mean, right? It means whatever judges say that it means. Internal institutional constraints in the dynamic court view are also weak. Standing rules, so in other words, the rules of justiciability are pretty broad. There are also a ton of lawyers in the United States, and the bar for filing a lawsuit is actually pretty low. Court filing fees aren't that expensive. And so we have a ton of lawyers, and the number of lawyers is also growing. The courts are able to place themselves in the middle of political debates using their injunctive powers. So, for example, they'll issue an injunction where prisons are under court supervision for a period of time if they've been seen as violating regulations. As for external institutional constraints, the dynamic court view would argue that the appointment process is not limiting, but is actually empowering. And why is that the case? Well, it's because judges have life tenure, right? And it's really hard for them to be removed. Culturally, the dynamic court view would argue that cultural constraints are actually quite weak. So there's something that political scientists who study this sort of thing call the American Creed. And so this is the fact that these buzzwords that American politics and American politicians always go back to, like liberty and equality and freedom, these in and of themselves are vague terms, right? And so just as an opponent of gay marriage can claim that he's opposed to gay marriage because it violates his religious freedom, well, gay people argued before the court in Obergefell versus Hodges that they wanted the freedom to be able to legally marry whoever they choose, right? So the word freedom here can be used in multiple contexts. All right, so on to the final part of this table. The conception of politics when it comes to the dynamic court view is not that politics is just distribution of goods and services, but that politics is more fluid than that. And politics is the construction of issues and the placing of policy alternatives on the table. And so in this way, the court is able to bring desegregation into the public eye. They're able to bring it onto the agenda of the elected branches. And then we see the Civil Rights Act of 1964 and the Voting Rights Act of 1965. And so it's not just that the court is handing out desegregation themselves throughout the South, but instead they're forcing Americans and forcing the elected branches to confront these issues. So again, just a quick review of these definitions of politics. In the constrained court view, politics becomes the struggle over who gets what, when, and how. And the constitutive definition of politics, which falls under the dynamic court view, is that politics are the processes by which public issues are framed and placed on the agenda. Policy alternatives are defined and prioritized, and that policy initiatives are enacted and implemented. And so if you have this broader view of politics, then the measuring stick for the court's ability to be dynamic or constrained is really fundamentally different than if politics is simply the struggle over who gets what, when, and how. I'll talk more about these terms in our class on September 19th, because I know that this can be kind of confusing. So here are the takeaways. The constrained court view argues that the American system provides multiple checks against judicial policymaking, and that when elected branches talk, the courts tend to listen. The dynamic court view, on the other hand, says that the American system is really a recipe for legislative inertia. And the way that politics is set up in the United States, it's much easier for branches to not act, the elected branches to not act, than to act. And as a result, this really gives the courts ample room to maneuver. And not only that, but the elected branches are usually much too busy arguing with each other to talk back to the courts. So finally, given the comparative perspective, political culture in the U.S., what we call demands for total justice, and fragmented political institutions, I think it's safe to say that we expect the courts to be dynamic. Thus, we should ask, under what conditions are U.S. courts constrained? Okay? The answer to this is that usually the greater the ideological cohesion among the elected branches, and this is what we call unified government, the greater the strategic opportunity for dynamism under the courts. I'll talk more about this a little bit later. So one more example here of this in action. We can look at Brown versus Board, the famous, obvious desegregation case, which we've talked a lot about, and then Roe versus Wade, the abortion case from 1974. So let's ask the question here, and we're comparing it much as we did with Katrina. So were the courts passive? Yeah, they were. But entrepreneurial lawyers in Brown versus Board, and they were with the NAACP, they were able to successfully set the agenda, and the court heard the claim. Same with Roe versus Wade. Did interest groups win in Brown versus Board? Yeah, they did. Roe versus Wade, liberals mostly yes, conservatives mostly no. So here, this next box, did the courts directly change the distribution of services? In Brown versus Board, they did not, right? Courts did not immediately become desegregated overnight. Were they able to change the distribution of goods and services in Roe versus Wade? No, they were not immediately. Did the courts frame the politics? And here is the constitutive definition of politics. In Brown versus Board, yes, they did. In Roe versus Wade, they were also able to frame the politics. Did interest groups use court outcomes as a political lever? In Brown versus Board, the answer is yes. Roe versus Wade, the answer is a mixed bag. So liberals did not really use the Roe versus Wade outcome to then push for more legislation. Conservatives, on the other hand, were really successful at doing this. So they did use it as a lever. There was a backlash first, and then conservatives in the South really began to take up the anti-abortion movement, just as liberals in Congress began to take up the civil rights agenda after Brown versus Board. All right, so that is the end of the slideshow for today. I realize there was a lot of information that I just went over. So do your best to answer the discussion board questions, and then we'll spend a lot of time in class on September 19th going back over some of this stuff just to make sure that everybody's on the same page before we turn to part 2 of the course. All right, thanks so much.